Based on a technicality, Cosby's 14th Amendment right to due process was violated, so the whole thing needs to get thrown out. That is not a verdict of innocent. Hi there, my name's Leeja. I'm a real-life lawyer on a mission to demystify the law and how it affects your everyday life. Today, we're going to talk about Bill Cosby. That's right, the Pennsylvania Supreme Court just overturned his 3 aggravated assault convictions, and we got to talk about why. This case has implications in terms of both victims' rights, but also prosecutorial oversight, so let's get a little controversial. Major content warning, obviously we're going to be talking about sexual assault and some other pretty horrifying shit, so you've been warned. Let me also note that I'm a lawyer, but I'm not your lawyer, and nothing that I say should be construed as legal advice. You should always seek the advice of a licensed attorney before making any legal decisions. Okay, let's talk about this case. It's a bit of a complicated backstory. The Pennsylvania Supreme Court decision was 79 pages long, and I read them all so that you don't have to. It was released on June 30th. I'll link it below because it really does a good job of thoroughly reviewing all of the facts from the trial below. If you want the full gory details, check out the link in the description. So let's just get into the background. In 2002, a woman named Andrea Constand was the director of basketball at Temple University. She's a former professional basketball player, and at the time she had aspirations of going into sports broadcasting. She met Bill Cosby because he was like involved in Temple basketball, I guess, and they started up a friendship. She would go over to his place, or they would go places together. They would talk about basketball. He would make a sexual advance. She would say no. It would kind of went like that. Then one night in 2004, when she was over at Bill Cosby's place, he offered her some blue pills, and she took them. After taking the pills, she lost consciousness, and when she came to, he was assaulting her. The gory details are all in the opinion, and I'll let you read those if you want. She didn't report the event, and went on to continue having a casual friendship with Bill Cosby. They had phone conversations, they got dinner. There was one incident where she tried to confront him about it, but he was really evasive about what the pills were that he gave her, so she just kind of got up and left. She's originally from Canada, so she moved back to Canada. Cosby was in town one time. He invited her to a show. Her mom loved him, so they both went. And according to the opinion, Constand kept the January 2004 incident to herself for nearly a year until one night in January 2005 when she bolted awake crying and decided to call her mother for advice. After that happened, they filed a police report in Canada, which then eventually got transferred to Montgomery County in Pennsylvania, which is where Cosby's house is, where the incident took place. At one point, Constand recorded a conversation between the two of them where, again, he wouldn't tell her what the little blue pills were, and he also offered to pay for her education and tried to discuss her future career in sports broadcasting. After she filed the police report, 2 of Bill Cosby's people called her. One was someone trying to set up an opportunity for her to fly down somewhere in the States to see a show that Cosby was putting on, and then the second call was from his lawyer who was trying to set up a trust fund for her education. She declined both. On January 24th, 2005, the district attorney for Montgomery County in Pennsylvania, Bruce Castor, issued a press release saying that Bill Cosby was under investigation for sexual assault. The cops questioned Cosby, who claimed that the night that she was over there, she claimed she was having a hard time sleeping, so he gave her 1.5 Benadryl pills but didn't tell her what they were. He then claimed that they started fooling around on the couch and she never resisted or told him to stop. He later supplied the police with the pills he claims that he gave her, and the police tested them and they came back as Benadryl. All of his responses to police questioning were via written questions. It wasn't face-to-face interviews, at least initially. Then District Attorney Bruce Castor reviewed the Cosby questionnaire and the statements by Constand, and he claims he was troubled by the fact that it took Constand a whole entire year to come forward with her accusation, which, like, if he were in any way trained in like trauma response or working with survivors of sexual assault, that like would not have been concerning at all, but we'll get to that. He was also troubled by the fact that Constand's story had some inconsistencies and that she kept in contact with Cosby after the alleged assault occurred, which again, if you had any experience at all with trauma response or working with survivors of sexual assault, would again not be at all out of the norm, but that's fine. According to the opinion, DA Castor found these recurring interactions between a complainant and an alleged perpetrator to be atypical. Literally, what? If you have ever had any sort of background in working with sexual assault survivors, domestic violence survivors, relationship abuse survivors, or if you've survived any of those things, keeping in contact with your abuser is far from atypical. And if this guy had any training in that area, he would know that. So he decided that she wasn't credible based on her inconsistencies and the fact that she stayed in contact with Cosby. Castor also decided that the evidence that she had gathered of the recordings of her conversations with Bill Cosby would not have been admissible in a trial because it wasn't consensual on his part, and also it could be seen as him trying to bribe her. Because of all of these issues that he spotted in this case, he determined that a criminal trial would likely be unsuccessful against Bill Cosby. And this was totally within his discretion. There's a lot of what's called prosecutorial discretion to charge or not to charge certain cases. Basically, prosecutors could not press charges every time there's an accusation. There's just not enough time in a day for them to get to all of the cases. They need to make decisions based on which cases they think are actually triable and which might actually win in court. The number of requested criminal trials that exist in the United States far outweighs the amount of prosecutorial time that exists. So that was within his right to make that call. It's also an immense amount of power. They get to decide who gets charged and who doesn't. And a lot of district attorneys or county attorneys, similar positions, are elected. I know that local politics seems real boring, and every time you go to vote, like that's the bottom of the list of what you might be interested and thinking about and planning for when you vote, but man, the amount that local elected officials dictate your life and the lives of the people in your community is pretty insane. So this guy had this power to determine whether or not to prosecute Bill Cosby, and based on his assessment of the case, there wasn't a strong case against him, and so it wasn't worth prosecutorial time to move forward with the case. Also, just by way of brief background, Bruce Castor is a Republican, and he actually served as one of the lead counsel on Trump's second impeachment trial in defense of Trump. I don't know if you watched opening arguments, but I sure did, and his were bad according to many people, including Trump himself. It was kind of just a lot of rambling.
These were persuasive documents about why the Constitution is a good thing. Because if the individual state legislatures didn't adopt the Constitution, we would not have it.
Incoherence. So that's Bruce Castor, the guy who decided not to prosecute Bill Cosby. I'm just saying. Anyway, back to 2005. At this time, when Bruce Castor decided that he didn't want to press charges, he did decide that he wanted Andrea Constand to be able to have her day in court just on the civil side. So this is where the Fifth Amendment comes into play in this case. So the Fifth Amendment says a number of things, but today we're concerned with the provision of the Fifth Amendment that says that you do not have to make any self-incriminating statements, also known as pleading the Fifth. This protection only applies where criminal prosecution is possible. It doesn't apply in a civil context, where say an assault survivor sues her abuser in civil court for monetary damages. Fifth Amendment does not apply there. However, where there is a pending criminal trial, it might apply, because anything that is said during a civil trial could affect a criminal trial because it becomes the public record. A lot of times when there is a concurrent civil and criminal trial happening, the civil trial will be stayed or paused pending that criminal trial because the rules of evidence in criminal trials are different from civil trials. So things that may not be admissible in a criminal trial but are admissible in a civil trial could come out during that civil trial and could then taint the criminal trial in a way that people want to avoid because it gets in the way of constitutional protections that are in place during a criminal trial that we're less concerned about during a civil trial. Because during a criminal trial, there's the potential that someone's freedom, liberty could be taken away because they're sent to prison, whereas in a civil trial, the outcome is usually monetary damages. So here, the district attorney Castor reasoned that if he said that they weren't going to prosecute Bill Cosby for this assault, then he would not be able to plead the Fifth in the civil case that Constand was going to be bringing against him, meaning that she would have more evidence against him in the civil trial to then be able to win and get some sort of remedy in a way that Castor didn't believe that she would be able to get on the criminal side. So in this subsequent civil trial, Bill Cosby wouldn't be able to plead the Fifth, and he would have to answer whatever questions are asked of him because he would be subpoenaed, which means that you have to respond. The reason why Constand would be more likely to get a civil remedy versus a criminal remedy is because of the difference in what's known as the burden of proof. So in a criminal case, the burden of proof is beyond a reasonable doubt. That means that the evidence has to show beyond a reasonable doubt that the defendant did the crime. This is a high bar because, again, we're taking away someone's liberty, so we want to make sure that we're sure. Is that always the case? Do we get it right all the time? No, we do not. But that's the theory, at least. So in a civil case, again, because liberty isn't implicated, the burden of proof is lower. It's by a preponderance of the evidence, meaning that the plaintiff has to show that the evidence tends to prove that the defendant did the thing. Therefore, because the bar is lower, it's easier to prove, and the civil plaintiff is more likely to get some sort of remedy, again, usually monetary damages. Now, based on the opinion that I read from the Supreme Court of Pennsylvania, it sounds like Castor made a thorough assessment, read everything, took the time that this case deserved to make his determination that it wasn't winnable. The issue here really isn't so much with the investigation or even with Castor's legal assessment, both regarding the Fifth Amendment and regarding the ability to win the trial, because it was 2005. Montgomery County is in a suburb of Philadelphia. So just think about suburbia in 2005. How likely was a jury in suburban Philadelphia going to find Bill Cosby, a beloved family figure at that point, guilty of sexual assault in a case where it is purely he said, she said evidence? Are they gonna believe Bill Cosby, or are they gonna believe this random woman? So the real problem, in my mind at least, is with society, just kind of in general, especially in 2005, but then also with Castor and his understanding of sexual assault, trauma, the body's trauma response, and how a person responds to trauma. Because if you've ever survived sexual assault or worked with people who have, you know that humans aren't robots. Trauma takes time to process. Sometimes it takes time to even realize what happened to you. You don't just get assaulted and then immediately think like, ah yes, this was a violation of my rights. Let's go to the police immediately. It's not usually the first thing, at least in my experience working with victims of sexual assault and being a survivor of sexual assault, not necessarily your first thought. You usually have to sit with it and process it and figure out what went wrong. And there's a lot of self-blame. What did I do to elicit this behavior towards me? There's also the instinct to just try to brush it off, because a lot of times the person who's assaulting you acts like it's no big deal. And a lot of times the person being assaulted is a woman who's been told their entire life to just be cool, be chill, stop being so uppity, be calm. Why are you so worked up? Calm down. So you try to play it cool, until 1 year later, all of a sudden you wake up in the middle of the night sobbing because your body has finally caught up to the traumatic experience to a point where you can at least begin the process of understanding what happened to you. This is extremely human stuff. This is primal. This does not follow legal logic. And if you're a middle-aged Republican white man who's never experienced this or worked with people who have experienced it, or tried to understand the psychology behind a trauma response, which was even less developed in 2005 than it is today, you're going to try to apply logic to an inherently illogical situation and trauma response. You're going to look to the victim's erratic memory, to their delayed reporting, to their continued connection with the abuser, and you're going to think, well, that doesn't make sense. So clearly something's wrong with the victim. She's not credible, so I'm not gonna prosecute. So Castor, again, was correct in his assessment that the trial probably wouldn't be winnable because he would not be prosecuting it through a trauma-informed lens, which is essential, especially for prosecutors, but I think for attorneys in general, and it is training that is woefully missing in our judicial system. That being said though, even if he had tried to prosecute it through a trauma-informed lens, it was still 2005 in suburban Pennsylvania, and he would have been with a jury of those peers. The likelihood of them getting it, even if the prosecutor got it, was also probably pretty slim. As a society, we weren't there in 2005, and I'd venture a guess that we're still not quite there yet. Me Too movement and all. Anyway, okay, I got off on a tangent. Let's continue with the story. So Castor decides not to prosecute. He releases a press release saying as such, and Constan moves forward with a civil trial. During that trial, Cosby was subpoenaed to testify at depositions. He did 4 depositions, which are basically sworn statements where the witness or defendant is questioned. It's under oath, so lying is perjury. He again testified that he gave her 1.5 pills of Benadryl because she complained that she wasn't able to sleep, and that's what he uses to help himself sleep. He also admitted that they engaged in sexual activity after she took the pills. He also admitted that he spoke on the phone with Constance's mother, but declined to tell her what the pills were because he was afraid that she was gonna think he was an old pervert who drugged her daughter, which, like, yeah, accurate assessment of the situation, Bill. During that deposition, he also admitted that he had given women quaaludes with whom he wanted to have sex. That suit eventually settled for $3.38 million, and the records for that case were sealed until 2015 when a media inquiry got them unsealed. By 2015, there was a new district attorney in town, Risa Vetri-Furman, and she decided to reopen the case. Her decision to reopen was based on this newly released testimony that was from the 2005 case but didn't come to light until 2015. As part of the investigation, she spoke with Constand, who agreed to cooperate with the district attorney's office, even though supposedly the settlement included a provision where she would not cooperate with future investigations against Bill Cosby. So Furman decided to move ahead with 3 counts of aggravated assault against Bill Cosby. When Cosby objected based on the promise that he claimed he got from the former prosecutor, the trial court denied his objection, saying that it was just prosecutorial discretion. It wasn't a binding promise that he would never be prosecuted for the crime. It was literally just a press release. The court also noted in that opinion that the district attorney Castor did not actually ever meet with Constand to discuss the assault charges, and that after they had found different women who had come forward to allege that Cosby had assaulted them, Castor had dismissed all of them as not credible. He is also quoted as saying, "In Pennsylvania, we charge people for criminal conduct. We don't charge people with making a mistake or doing something foolish," though he claims he doesn't recall making that statement. The trial court also found Castor's story about what his actual intent with the press release and his promise to Cosby was. They found it inconsistent, which is very interesting that Castor has an inconsistent story after dismissing so many sexual assault survivors for inconsistencies in their stories. The trial court also said that even if there had been a grant of immunity to Cosby for any future prosecution, it would not have been reasonable for Cosby to have relied on that promise because it was literally just in the form of a press release. Like, it was not a written contract or any formal signed document. It was a press release. Cosby had competent legal counsel, and they should have known better than to rely on that. So the trial went ahead, but the jury was unable to come to a consensus, so they had to do a retrial. At that trial, 5 witnesses came forward to testify against Cosby for alleged sexual abuse. Their cases were largely stemming from the 70s and 80s, so the statute of limitations had passed, so they couldn't prosecute him based on those actions, but they could use that testimony in court. So the rules of evidence say that you can't use past acts to prove propensity to do future acts. You can't say like, well, he did it this one time, so he's going to do it this other times. However, you can use past bad acts to show intent or motive or a kind of scheme for doing things, a pattern of behavior. You can also use it to show absence of mistake, meaning that he knew what he was doing because he did it before. So the court allowed these witnesses to testify. There were 19 who came forward, but the court decided to limit it to 5 because 5 would get the point across, but allowing 19 in might be overly prejudicial against Cosby. Like, if a jury's gonna hear woman after woman after woman come forward and say what he did to them, they're going to just hate him without actually deliberating as to the facts of this specific incident and this specific case. So in order to avoid that level of prejudice, the trial court limited it to only 5 women. The trial court also admitted Cosby's testimony relating to his use of quaaludes on women in the past, and that deposition testimony about the quaaludes is important to note because he made that testimony after having received that promise from Castor that he was not going to be prosecuted, meaning that his Fifth Amendment rights had been stripped away, and so he did not have the right not to incriminate himself at that point. After that trial, he was convicted of all 3 counts of aggravated assault, and he was sentenced to 3 to 10 years in prison. So Cosby obviously appealed this decision, and the appellate court in Pennsylvania upheld his conviction, saying that it was essential to include his testimony about the quaaludes to show that he had an understanding of how depressants affect the body, depressants being either quaaludes or Benadryl, for example, and that he had a habit of giving depressants to women that he wanted to have sex with. It also was essential, according to the appellate court, to overcome the he said, she said nature of the case. Again, who are you going to believe, Bill Cosby or this random woman? Well, if you have evidence that he has used quaaludes in the past on women and have 5 women coming forward to testify as to that, you're going to more likely believe the woman than Bill Cosby, maybe. The appellate court also held that there was no authority saying that a random district attorney could just grant immunity to a person, especially not in a press release. The law states that the district attorney would have to go to a court to get that kind of immunity granted, and therefore it wasn't reasonable for Cosby to have relied on this promise not to prosecute. Okay, so then it was appealed again, and the Pennsylvania Supreme Court overturned his conviction. What did they say? First of all, they agreed that Castor's testimony as to his reasoning behind the creation of the press release, his actual intent with it, was inconsistent inconsistent. Sometimes he would say that he meant to grant complete immunity to Cosby forever. Sometimes he said that wasn't his intent. So the Supreme Court agreed his intent was inconsistent based on his testimony. They also confirmed that his press release only amounted to prosecutorial discretion, meaning it was just a decision that him as a prosecutor made not to prosecute, that didn't have any sort of like binding immunity or have any more power than your average act of prosecutorial discretion. However, the Supreme Court decided that even though it wasn't technically binding, because Cosby relied upon the promise to his constitutional detriment, meaning that his constitutional rights were taken away because he relied upon this promise from the prosecutor, then the promise was still binding. And due process, which is promised to him by the 14th Amendment of the Constitution, requires that the promise be enforced. They compared this to the protections that defendants are given during guilty pleas. So if a prosecutor promises them something like lenience or something like that in exchange for pleading guilty and then like recants that or something, that's a violation of the defendant's due process rights. And this makes sense. I mean, we don't want prosecutors talking to defendants who have not been convicted, innocent until proven guilty. We don't want prosecutors making deals with defendants and then recanting them, and then the defendant goes to jail after pleading guilty when the prosecutor promised them something else, you know? We want defendants to understand the nature of the charges against them and what they could be facing when they enter a guilty plea. And then the court went on to analyze the actual text of the press release in a way that I found to be like fundamentally incorrect. So the trial court initially determined that the press release was not meant to be a binding promise to Cosby, and they based this decision on one specific sentence. The sentence in the press release said, "District Attorney Castor cautions all parties to this matter that he will reconsider this decision should the need arise." The trial court found that the words "this decision" in that sentence meant his decision not to prosecute Cosby, meaning that this entire sentence meant that should the need arise, he would go back and reconsider his decision not to prosecute Cosby, which would mean that it's not a binding promise that he will never be prosecuted, so it was not reliable for him to rely on this promise. However, the Pennsylvania Supreme Court read that this decision, those words in that sentence, did not mean the decision to charge Cosby. They provided the entire paragraph of the press release as context, and this is what the whole paragraph said. "Because a civil action with a much lower standard for proof is possible, the district attorney renders no opinion concerning the credibility of any party involved so as to not contribute to the publicity and taint potential jurors. The district attorney does not intend to expound publicly on the details of his decision for fear that his opinions and analysis might be given undue weight by jurors in any contemplated civil action. District Attorney Castor cautions all parties to this matter that he will reconsider this decision should the need arise. Much exists in this investigation that could be used by others to portray persons on both sides of the issues in a less than flattering light. The district attorney encourages the parties to resolve their dispute from this point forward with a minimum of rhetoric." So the Pennsylvania Supreme Court specifically looked at the two sentences. "The district attorney does not intend to expound publicly on the details of his decision for fear that his opinions and analysis might be given undue weight by jurors in any contemplated civil action. District Attorney Castor cautions all parties to this matter that he will reconsider this decision should the need arise." The Pennsylvania Supreme Court read into this that the sentence, "District Attorney Castor cautions all parties to this matter that he will reconsider this decision should the need arise," this decision meant his decision not to comment publicly on his decision not to charge Cosby. That's how the Pennsylvania Supreme Court read it. However, they spent much of the opinion talking about contract law theory. And in contract law, when there's a word in a contract that doesn't make sense, you look for how it's used in other places in the contract to try to give it meaning. For me, if I'm looking at this paragraph, the sentence before "this decision" appears, the word "decision" is used again. And in that sentence, decision is meant to refer to Castor's decision not to prosecute. The Supreme Court even pointed that out, that his decision not to prosecute is what he meant by that first sentence. So then when he goes on to the second sentence to again reference "this decision," wouldn't it make sense that decision in that sentence also means his decision not to charge Cosby? So the way I read it, the sentence means that he will reconsider his decision not to charge Cosby, which is what the trial court said as well, meaning that this press release was not meant to be binding living forever, meaning that it wasn't reasonable for Cosby to have relied on it when he waived his Fifth Amendment right to not incriminate himself and testified at that civil trial, meaning that his testimony about the Quaaludes should be admissible because it didn't violate his Fifth Amendment rights, meaning that his conviction should not have been overturned. Literally, this whole decision pretty much rides on the word decision. And this is what lawyers do. They quibble over the meaning of a single word, but it's really important. Was it reasonable for Bill Cosby to have relied on that press release in assuming that he didn't have a Fifth Amendment right to not self-incriminate? The trial court said no, it wasn't reasonable. I don't think it was either, based on this press release. But the Supreme Court of Pennsylvania decided that it was reasonable for Bill Cosby to rely on that promise to his constitutional detriment. Therefore, his due process rights were violated. Therefore, his conviction should be overturned. And then the Supreme Court went further and said that because he relied to his detriment on this promise, both in the criminal side of the trial, but also during the civil trial, and that cost him $3.38 million, that means that the remedy of having a retrial where they just don't include the Quaalude evidence, which was an option, it was an option, they decided that that was not the best remedy, that the only possible remedy was to just completely throw out his conviction and not allow a retrial, basically enforce the promise that was originally made that he would not be prosecuted. So again, the only part of Cosby's trial that was affected by this was his deposition testimony about the Quaaludes. They could have just ordered a retrial and have that evidence be excluded, but instead they said, nope, that's not a good enough remedy. He's been so damaged by this denial of his constitutional rights, not only because of the criminal trial, but also because of that $3.38 million, that this is the only possible remedy. They don't talk at all about his alleged 60 victims. They don't talk about their harm. They don't talk about the needs of justice and the prejudice against them versus Cosby. They don't really talk about any of this. They don't weigh any of it. Because again, this decision doesn't say Cosby is innocent. Based on a technicality, Cosby's 14th Amendment right to due process was violated, so the whole thing needs to get thrown out. That is not a verdict of innocent. So they decided to throw the whole thing out because he was so damaged without really taking any time to consider the damage that he has caused and that he admitted to causing. Cosby's harm that he suffered was monetary. The harm he caused and that he admitted to causing was emotional and physical and will stick with his victims for their entire lives. And the court didn't mention one word of that. So, okay, so what does this all mean? First of all, as I hope I've made clear, this is not a declaration of Bill Cosby's innocence. It was a procedural misstep, not a declaration of not guilty. Second of all, we can take from this that coming forward about sexual assault allegations is often horrifying and re-traumatizing and fruitless, full stop. And one part of this problem is because we have a country that is chock full of prosecutors who are not trained in trauma response or to prosecute cases through a trauma response lens. Some are, but a lot aren't, especially the prosecutors who are higher up on the chain of command, like the district attorneys and the US attorneys. There is not a history of trauma-informed prosecution in this country. We need to have district attorneys and other prosecutors with a trauma-informed background so that when they have a witness or a victim come forward who says that they were hurt, they can look at inconsistencies in that victim's statement or their continued contact with their abuser and other issues like this and say, no, that's actually really typical of a trauma victim. This is normal trauma response because I am educated in this area, so I understand what to look for. By doing that, then they are able to use their power and discretion, which is immense, to choose who to prosecute based on understanding how a victim responds to that kind of trauma. They can then use that knowledge while they're prosecuting the case to help jurors understand why a victim acts the way that they do and find that victim more credible. Cosby's release from prison, as horrible as it is for his alleged 60 victims and for pretty much anyone who's ever survived sexual assault, should not be seen as a condemnation of coming forward about sexual assault or as a damnation of the entirety of the Me Too movement. It should be seen as an opportunity to examine who prosecutes crimes in this country and what standards that we're holding them to. Because often they are elected officials. They work for us. We pay their salaries. And they wield a lot of power, and it largely goes unchecked because people don't understand the system, and a lot of times it's local politics that people are less involved with. So if if nothing else, I challenge you to figure out who your district or county attorney is and whether or not they are elected. And some are appointed. Who appointed them? What party are they affiliated with? What did they do before becoming prosecutors? Do they have any sort of background in defense work, defending criminals, or in trauma-related work? We should hold them to high standards because they're the ones who are putting people in prison, who are taking away people's liberties. But they're also the ones who can mess up or cut deals with people based on their fame or their money. See, for example, the entirety of the Jeffrey Epstein case, which is a video I'd like to do at some point in the future. This is really hyper-local politics type work, and it affects the fabric of our daily lives and of our community in ways that we don't often see because we're so focused on who's in the White House. So that's my spiel in support of taking this case as a way to learn more about the system and how it affects your everyday life. I hope that you found this helpful. I know this is a really confusing case and that a lot of the concepts are kind of getting a little bit into the weeds of like constitutional law and rules of evidence and things like that, but that's the background of Bill Cosby's case, and there's no retrial, at least for this alleged sexual assault, and a lot of his victims came forward about assaults that happened in the 70s and 80s, so those statute of limitations have passed. It seems, at least at this point, that Cosby is going to just walk free. I even saw mention that he might start doing stand-up again. Yikes. I want to know who wants to go to that show. Anyway, comment below, what do you think about this case? Do you think that it should have been thrown out? Do you think that he should still be in jail? Do you believe him over the people who came forward about him? Tell me all of your thoughts below. Thanks so much for watching. Have a good day. Goodbye.